Well, it's 11:30, so I'm going to begin, assuming that we're all logged in. Now, welcome to those of you who are just logging in now. Welcome to this webinar. This is one that we're all very, very much looking forward to discussing, an issue that is tough, is challenging, is quite confronting, of course, but what a panel we've put together today to talk about this. Our theme is Beyond Me Too, Sexism, Workplace Harassment and Law Reform. But before I begin, I want to acknowledge that I am based in Canberra and therefore meeting on Ngunnawal land with the rest of you, although I'm meeting you virtually. Some of us are here in Canberra on Ngunnawal land, and we pay our respect to the elders past, present and emerging. But you have registered from all around the country, which is fantastic to see. There are, I think we're up to several hundred joining us this morning, which is just lovely. Thank you for joining us. And given you're around the country, we're meeting on land right across the nation. So welcome. Now, our title, Beyond Me Too, Sexism, Workplace Harassment and Law Reform, as I say, is a challenging one. The panel we've put together, I think, well, I'm sure you'll agree with me, is an incredibly well-qualified one to discuss this subject. First, we are joined by Jacqueline Maley. Jacqueline is a multi-award-winning journalist with the Sydney Morning Herald and Fairfax, and a columnist, and she indeed is one of the key lead journalists who broke the recent story around the revelations at the High Court around former Justice Dyson Heydon. Welcome, Jacqueline. Can you hear us?
Yeah, thank you for having me. It's a pleasure.
Lovely to have you. And where are you beaming in from?
From my home in Sydney, which is poorly lit, as you can see, but hopefully it does the job.
It does. We can see you. Lovely to have you here. We're also joined by Kate Jenkins. Now, Kate, of course, is no stranger to any of you. Kate is our Sex Discrimination Commissioner at the Australian High Commission. Kate, earlier this year, released an extraordinary report, a mammoth report, which is actually behind her on her bookshelf there over her right shoulder. It is huge. But I say it's an extraordinary report because it is an amazing read, perhaps one of the most comprehensive reports of its kind. Over 18 months, her team surveyed right across Australia workplaces and the issue of sexual harassment. And the report was released publicly in March of this year. I believe it's been with the government for a little bit longer. So we'll be very interested to hear how government has responded to that. Now, Kate, where are you beaming in from?
I'm coming from Boonwurrung land, which is south of Melbourne. So I'm out of Melbourne. So we're covering a bit of the country in this webinar.
We certainly are. Well, lovely to have you with us. Thank you, Kate. And we have Professor Kim Rubenstein. Kim is again known to many of you. She's a leading scholar, gender scholar. She is also an international expert on active citizenship. She's a professor of law, was previously, or until recently, the director of the Centre for International and Public Law at ANU. But we are very, very pleased to say she is now with us at the University of Canberra, and she's one of the co-directors of the 50/50 by 2030 Foundation. Welcome, Kim, and where are you beaming in from?
I'm actually beaming in from Monica, which is not far from where you're beaming in from in Canberra. So
right, so I don't need to yell to get to you.
It's a bit bizarre, really, to talk to each other through this screen when we're probably only less than a kilometre away from each other.
I know, it's extraordinary. What strange times. But look, obviously, we're all getting used to it. And there are advantages that we can bring together, not just a panel like this, but I think we're up to about 300 now, people across the nation joining us. Look, to set the scene, I just want to make reference to the story that broke on the 22nd of June of this year, which was written by Jacqueline Maley. And of course, you know, this was the story of former Justice Dyson Heydon, one of the nation's preeminent legal minds, and allegations that he had sexually harassed 6 young female associates, and that those claims of sexual harassment had been found to be believed by an independent inquiry. The Chief Justice of the High Court, Susan Kiefel, publicly apologised and personally to those women. And of course, this is a story unlike any other that is broken in Australia. A man in such a position of power, but to have the High Court actually publicly apologise has never happened before. So this sets the scene for our broader discussion. Of course, we won't be discussing the details of that case. We're not able to do that. And some of the parties in that dispute have indicated that they may bring their matter to the Australian Human Rights Commission. So we will tread very carefully as to how we discuss that story. Look, Jacqueline, I want to kick off with you. And as a journalist, I've got to say, as I read that story, like everyone else, when it pinged into my news feed on that day, I found myself gobsmacked, wondering how on earth did this get to print? Because it is so difficult in Australia to tell a story such as this. So can you just take us through the process a little bit?
Yeah, we had, I mean, we were lucky in a sense that the High Court had done its independent investigation. And to be honest, that gave us a lot of legal cover, if you like, because we knew that we'd be fairly well covered reporting the fact of the independent investigation and its findings that, you know, he had indeed sexually harassed 6 associates. And then, but we knew that the behaviour, the allegations of the behaviour were far broader than just those allegations, and they spanned many years and took place, or allegedly took place, under the guise of many different institutions. So we knew there was a really even bigger story there, and we wanted to be able to publish all of that. It took a long time. Kate McClymont, my colleague, first heard about the, heard Dyson Hayden's name mentioned in the context of the Me Too stories that she had written back in 2018 about John Burke and Craig McLaughlin. And as you'll probably recall, as everyone will recall, there was a big fervour about, the Me Too movement and an excitement, I think, about it. And everybody was wondering who would be the first to kind of report those kinds of stories in Australia. And of course it was Kate, and she did it with great, with her customary brilliance. So she got a lot of tips, and one of those tips was about Dyson Hayden. She made some inquiries and made some phone calls, but it was difficult to firm up, and the defamation side of things was obviously very risky. So then the High Court sort of process happened separately, with the women, or some of the women, going through a lawyer and taking their complaints to the High Court directly. So once that process was happening, that was sort of happening on one track, if you like. Separately, I had heard I'd heard from a contact about Dyson Hayden myself, and I actually rang Kate. I made some phone calls and made a few inquiries, and then I rang Kate to ask her advice on something. And I didn't even name him. I just said, it's a former judge. And she was like, oh, is it Dyson Hayden? And I said, yeah. And she said, well, this is what I've been doing in 2018. So then we joined forces, and we just put out a lot of phone calls. It was really just very basic journalism. We just phoned a lot of people. I did a freedom of information request from Oxford University, which helped firm up and corroborate some of the stuff we knew had happened there.
Can I ask you, did you actually approach each of the 6 female complainants who had spoken to Susan Keitel?
Yeah, we went through we had lists and lists of people who had been associates of the court, and we had, every time we spoke to someone, we said, is there anyone else that you think would be worthwhile speaking to? So the web went very, very wide, and we spoke to, we would have spoken to, I don't know, 50, 60 people in the course of the investigation. And not everybody was helpful, but people often will point you in the right direction, even if they can't help themselves. There's always a balance journalistically with those stories, as I'm sure you know, where you want to, we wanted to be as thorough and as kind of like as wide as we could in our investigation, but we also didn't want to tip we didn't want to tip our competitors off, and we didn't want to scare the horses, because the legal industry is pretty gossipy. So can
I just pull you up there just to get you to explain that a little bit further for non-journalists among the listeners. When you say you didn't want to scare the horses, do you mean because our defamation laws are so incredibly tight that you were concerned that you would be stopped before you got to print?
There is always that concern. Yeah, there's always that concern that can happen. I mean, you know, if you want to be really sort of mercenary about it, that's not, in a story like this, that wouldn't have necessarily been a bad thing. It would have, you know, because can you imagine, you know, reporting that a former Justice of the High Court has gotten a gag order basically out on the Sydney Morning Herald? Like that would have created
Great story, yeah.
Yeah. Yeah, there's always that. And also because we were dealing with women who had different levels of vulnerability, we had to be very careful of their feelings and their sensitivities. And if it's sort of, you know, some people didn't want to go on the record to the last minute. They didn't want to go on the record, or they didn't want to talk to you until they knew that other women were talking to you, and until it was all quite firm. So yeah, it was a delicate sort of balancing operation right up to the last minute. And then when we published it, we had to publish before we wanted to, because we thought one of our competitors was going to get it out before us.
Did you have to, or did you come to any arrangement at all with the High Court and with the Chief Justice in terms of when she wanted to make public details about her own internal independent investigation?
It's difficult. I don't want to sort of talk too much about how that all worked, but we were talking to the High Court through their official media, you know, channels. But we weren't working with the High Court in any.
Okay. Yeah. All right. I just want to move it on now to Kim. Kim, being obviously a professor of law, but also someone who is a barrister who does appear in the courts, and the High Court is an area of justice you are very familiar with. Were you surprised when you heard this story? It's now been referred to as one of the worst kept secrets. Was it being talked about?
So maybe I should put that my answer into context in terms of the three ways that I feel like I'm engaging with this story. One is, as you said, myself as a lawyer, and I, when I finished my law degree, I did 2.5 years in one of the large commercial law firms doing my articles. And so I experienced, and that's now almost 30 years ago, and I remember the experience of the culture of that environment, which I think is relevant. And to give one quick example to lead into that answer, when one of my group of intake were equal numbers of men and women, around 20 of us altogether. And one of the first people from our group to leave was one of the men, and the practice group that he was in, they took him to a tabletop bar as his farewell. So that was sort of the culture that I was aware of in a law firm 30 years ago. Whether that's changed much now, others can tell us. So in terms of surprise of the legal world's culture, no, broadly. The second point that I was going to say in terms of my way into this is the work that I've done doing oral history interviews with women lawyers, trailblazing women lawyers that are now all in the collection of the National Library of Australia. And there are a range of stories that won't be released until the terms of the interviewee to the public. And there are mixed stories, although none that I personally interviewed directly related to Dyson Heydon, but other stories of experiences of workplace bullying and sexual harassment in law. And the third sort of connection was, of course, Justice Heydon replaced Mary Gaudron, who was the first woman on the High Court. And back in 2002, when I was based in Washington, D.C. for 6 months on sabbatical, she was replaced by Dyson Heydon. And that was the first opinion piece that I've written multiple versions over the years now.
I remember that piece, yes. You were pointing.
It's not good enough. So that was my first engagement myself with Dyson Heydon. Being originally from Victoria, I didn't know of him. So being outside of New South Wales put me, I guess, away from that world in which he was operating. And so my world never interacted directly with Dyson Heydon's world. And so I had not directly heard any of the so-called stories that had been shared.
But given what you do know and your experience, were you shocked when you read not only Jacqueline's first piece, but the ongoing stories and it was pouring?
Yeah, I think we all continue to be shocked because it's just shocking. That's, I think, the first reaction, that you just shocked because it just seems so unacceptable. But then when you unpack it more, which is I guess what we're going to talk about later in terms of the nature of the legal hierarchy, the nature of the gendered norm of the male lawyer as being the norm, and how we have to unpack that. That's other work to do with women entering the public sphere. I mean, one of the aspects of our oral history project in making the claim that we needed to hear more of the women's stories is that women lawyers were unlike the first women doctors in that they were entering into the public sphere as opposed to women doctors entering into what is normally the private sphere. And once women enter that public sphere, there are these barriers in terms of what are the norms in the public sphere that don't sit well with women's lived experience. And that might be something we come back to about the
We'll come back to that, and certainly culture and structure of organisations and this particular industry. But Kate, on to you. Now, you've spent, as I said, 18 months or nearly 2 years really looking at the issue of sexual harassment in the workplace. You have heard hundreds of stories, if not thousands. Were you shocked?
Not one bit. So when I'm absolutely so not shocked. I'm just really pleased and really appreciative to Kate and Jackie about their sensitive reporting. Over my career, because I've been doing this inquiry in this role as Sex Discrimination Commissioner, but I too am a lawyer. I was 20 years in a law firm. I was a partner in a law firm. And I advised on discrimination cases and particularly sexual harassment cases. And the reality is, over those 20 years, the nature of the issues that came up in law firms, but in a lot of industries, did not change that much. So the Me Too moment for me when I was in that role was like this recognition, because I'm standing here and there's a book I edited in 2000 on sexual harassment at work. So almost 20 years to the day our inquiry came out. So the couple of things that I will say is, over my career, I have observed that we've got the laws in place. And originally, certainly my early career was all about the corporates realizing you have to do something about these laws. But over time, actually, I used to, so that was the 90s. The laws came in 84. The 90s, particularly the banks and a whole lot of corporates started to realize sexual harassment, that bad behavior is not okay. But then over a period, the cases didn't run. They got settled confidentially. The awards were really small. And so I saw over time that the corporate fear of these laws really, it wasn't as bad as they thought. And I am interested, as I've watched over time in the 2000s, what I noticed mattered to corporates was the reporting in the newspaper. The front page of the Fin Review
bad publicity
mattered. And people have heard me say, you know, at that point, I used to do, I said, you know, change happens through leadership or scandal, but the reality is it's usually the leadership that follows the scandal. So what I've noticed over time, and this might, I'm sort of anticipating, but just off the back of Jacqueline's conversation, is that the reporting has been an important motivator, and the Me Too movement itself was the next layer of that, of exposing the prevalence, exposing the nature and exposing the harm. And all of those things have been really important to push the community conversation forward that then reinforces what needs to be done. The one thing I would say, just, and Virginia, I know you're running this, but the one thing I'd say about this is we can talk about this one industry or this one person, but my perspective is that we need this to be a much broader conversation, because the reality is 1 in 3 Australian workers in the last 5 years have been harassed. It happens in so many different industries. There's power disparities, there's gender inequalities, there's different natures in each one. So when the reporting, which I think this has worked really well, the conversations about this have been a bit about the legal sector and about one person, but actually most of the conversations I've had have been people coming forward saying, actually, I can see that happens in my industry. And so that's a really constructive forward movement.
Okay, I want to get into your mammoth report and some of the key recommendations, but just before I do, I've had a few questions about social media. For those who want to share our conversation on social media, on Twitter, we're at Broad Agenda 5050, all one word, at Broad Agenda 5050. So please join us on that. Kate, 55 recommendations in the report. I'm interested to know what are the key ones that you are absolutely determined must come into play. But it seems to me, reading through it, that you're trying to flip the emphasis, or the onus, I should say, of sexual harassment reporting from the individual, from the woman, and predominantly it is women, to the employer taking on a much bigger duty or positive duty to police potential sexual harassment. Is that right?
That is absolutely right. And, you know, I think if you're going to ask me which is my favourite recommendation, it's like asking which is your favourite child. And the problem is really complex, so it's all intersecting. But if I go to the sort of the spirit at a really simple version of what's going on and how the current system is working, the reality is we've had the laws for a long time. Australia's been quite leading on that. And I would say particularly large employers have been taking action. They've been doing policies and training and complaints procedures. But when you look at the laws, they are really the only recourse for sexual harassment is if someone complains. And so that framing means that organisations, I've often said, there's more incentive for you to hide, stop or settle a complaint than there is to prevent the sexual harassment happening. So of the broad range of recommendations, there's some legal, there's some for business. Really at the core of it is to say that our system at the moment relies on the bravery of victims. They pay a high price, even in the cases where they win, they can lose their careers. And that the reality is, like other safety issues, the position should be that employers are responsible to prevent this. And even now, a lot of the conversations I have are all about what do you do when a complaint comes in. So my constant shift is, well, okay, that's how you deal with it, but then what are you going to do to make sure it doesn't happen again? And employers haven't really had that mindset, but they do on safety. So that's where I'm trying to shift them.
Okay. Jacqueline, coming back to you, in the many women you've spoken to, those involved particularly with this case, but more broadly, do you get a sense, or do the women talk about not having faith in their own workplaces to actually handle the complaint?
Yeah, I absolutely. And that was certainly the case in the High Court. And the High Court then, I mean, it wasn't even a question of having faith, but there was no avenue for these women to complain to. They didn't have a sexual harassment process. One of the women sort of talked about when they got an HR briefing, you know, as they did when they sort of were, you know, when they started employment, the HR briefing there was nothing in it about sexual harassment, and it seemed more intent on protecting the judges and the institution itself rather than its employees. And also the sort of specific relationship between an associate and a judge is more like it's almost like personal indenture. You know, you're like that person's I don't know, like little serf. So there's less a feeling that you're working for the government, if you will, than there is that you're working for that particular judge.
Kim, I want to bring this over to you because this gets to culture, because it's certainly not just the legal industry where power structures and hierarchical power structures dominate a workplace. And as we know, majority of powerful positions, leadership positions, are held by men. So how does this bring us back to rethinking our culture, our workplace culture?
Well, I think actually it's quite interesting that it's at the High Court at this particular time that those women brought the issue before the court, because we are, you know, if we go back to 2002 when I was complaining that they were replacing Justice Gordon with Justice Hayden, we're now at the point where we have a woman as Chief Justice and we have two other women sitting with her. So it's a 3-4 split. There was a point when there were two positions available that if they had been both filled by women, we would have had a 4-3 split of women on the High Court, and maybe that is what we should be working towards. But at the moment, we do have that 3-4 split, and I'm curious, and of course, I would need to speak to the complainants themselves about the fact that it was a woman as Chief Justice with other women on their bench that might have enabled them to feel more secure in bringing this issue before the court. I don't know
how dominant is that, though? I mean, how obvious is that?
Well, that's not the norm in our society or in workplaces, that we have a sufficient number of women equally as leaders in that space. And of course, you're doing a lovely plug into the banner behind you of the 50-50 by 2030 Foundation. But of course, in our move to this second stage of the foundation, what we really are concentrating on, and what I think this case does bring out, is the importance of bringing structure with culture. And within structure, in terms of leadership, if you don't have an equal representation or a strong representation of women as leaders within the workplace, then that flows on to cultures more broadly. It doesn't mean that all women act, in a perfect manner, but it is about the equality or gender parity in leadership having a flow down effect, so that the cultural changes that need to be made are more likely to be adopted and seen as normal rather than the abnormal. So I do think it's significant that it's happened. I mean, we would need to do more research with the complainants, but it is, I think, a timely reflection on the structural needs to be coupled with the cultural gender norm changes.
Kate, your report talks about the changing nature of the workplace, and it almost raises the question that's been in my mind, and particularly at a time like this: what is the workplace? And does going out for drinks or a dinner or to the bar with your boss and your superiors, at what point is there a grey line there between this is the workplace and this is personal life? I mean, social life. Do you see that as a really murky area for a lot of us?
I don't see it murky, but I do think it's confusing. And I might just reinforce just one thing first before I answer that, which is what Kim said. She said we need some more research. So I can tell you, it's big, but the reality is the one thing that we found is underpinning sexual harassment. The key driver was power disparities, and the key driver under that was gender inequality. So just supporting those conversations, a couple of things. One is that we know where there is better gender equality, but particularly at the leadership level, there is less harassment and there is better responses. So there is actually really clear views that if it does happen, people are safer to come forward. The action that's taken is better. And particularly if you've got a lot of men at the top, the research out of the US says you're more likely to be questioned rather than just accepted. It's not women say, oh, that happened. They say, I'll take action, so I don't think it's coincidental. In terms of the nature of work, I think that was a really hot topic in our review because in 1984, when the laws came in, sexual harassment at work was prohibited. Work was very much 9 to 5. You went, you attended. It was very clear. And what we found, and in fact, the ILO have done a convention, ILO 190, about harassment and violence in the world of work. And they call it the world of work. They no longer call it employment. Because there are so many multiple ways that now we work and engage. And just using the legal sector, because actually it's had it for a long time, there's associates with judges who deal with barristers, and then clients and law firms. None of these are actually connected by an employment relationship. So in our inquiry, what we came up with was that the laws have all these assumptions about work, and you can complain about work, but it's not even that question about the social and the social media and where it's actually even how am I connected to in work to that. So I know with judges that comes up, but it comes up in almost every industry. I'm the contractor that does this for that. So our recommendation in the inquiry was because our terms of reference were about sexual harassment at work, were expanding to make sure you capture all the different type of workers. I think there's lots less discussion when I started that, you know, at what time does the after work drinks be turn into personal? That was quite hot. We didn't find that was confusing now. People know work is quite fluid. But we did put some recommendations to expand the nature of work. But the reality is, I think where we will end up with our laws is that sexual harassment will be prohibited in all areas of public life. Queensland currently has that, Northern Territory and Tasmania. And that's because we hear public transport, street harassment, work harassment, rather than just saying it can happen anywhere but not here. I think as a society, we're going to say, no, it's just not acceptable.
Can I just pull you up on that point? It's a really important one, and a few of our participants have been asking questions about this, the disparity between state laws and national laws, and who takes responsibility. Is one of your recommendations to government that this does become a national or nationally enforced set of laws?
Yes. So the legal part of this is we think that the Sex Discrimination Act should become the best, you know, a better, so fill some holes, improve it. All the states, and some are better and some are worse, should be then amended to be consistent, but no less. So if they've got better, so that it all works together. Federating those laws, there's a whole history behind how complicated that is. So our recommendation was just saying, make them the same. Because what we heard, particularly with the lawyers coming together, and we're talking about lawyers, was if someone's got a complaint, they can look at Fair Work, they could call the Fair Work Ombudsman, they could call the Federal Commission, the State Commission, they could go WorkSafe, they could apply for workers' compensation. And almost if you're harassed, you need a law degree to figure out what you should do. And that should not be the case. And so our recommendations about the laws, but also the system, is we create a workplace sexual harassment council where all those regulators come together and work together, because we're all trying to do the same thing.
I want to get on to non-disclosure laws non-disclosure agreements and how that impacts the reporting. But before I do, I have to ask you this, Kate. As I said at the beginning of this, the government has had your report for, I think, since January, late January. What's happening? Are we getting a response? And are you getting the message that government gets what you're saying about the need for very radical reform?
Yes, I actually don't think my report is that radical. And actually, that's the good thing about it. It's really strongly evidence.
It'd be radical if it's taken into account, if it means that we actually have a changed system, a reformed system. That's radical.
Yes. So my sense, and I can't speak on behalf of government, but the process has been, they half funded the inquiry. They have actually been really engaged in this process. When it was launched, it was tabled on the 5th of March, which many of you will know. That's the last sitting day before everything changed. And at that point, there was a view that we're going to go through it. No question, it got put to one side because of the pressure and the decisions that had to be made rapidly. But however, I do know that they have now, and not, it didn't hurt, Jacqueline, to have your reporting sort of remind people of just the damage of these issues. So they are currently considering it. I know they're looking at both the legislative and the non-legislative recommendations, and I expect in coming months that we will get a response. And I expect there will be some really positive responses to the recommendations, because I haven't had any, there's no one who's said this is ridiculous. And we talked about, because of the spotlight on these issues, and particularly the most recent one, so this, Jacqueline, can make you wake up and think, oh, I might be helping change the country. This recommendation of a positive duty for employers, suddenly that is putting clear light when you look at a situation where someone so junior is the one that's meant to be responsible to fix this up. So I'm looking forward to the government response. I know they're considering it. I don't think they've come to a settled position, but I absolutely know it's on their agenda actively now.
Well, that's good to hear. Kim, non-disclosure agreements, are they a problem?
Well, I think Kate probably can extend the answer here, but in essence, once you are prevented from sharing that information, I guess it's a question about transparency as being a positive in any context. So if we think of freedom of information laws about government, openness in information, if we think about shining the light on areas of problematic behaviour, then the more knowledge and we have, I think it's so straightforward to say, the better and more improved the position will be. And so just as I think even more as a non-legal answer, but as a common sense answer in terms of the impact of those non-disclosure agreements on protecting their perpetrators rather than enabling other victims to be protected. I think that's, the first step, but I would imagine Kate has more to say because I think there are specific recommendations about that in her report as well.
Kate, non-disclosure agreements?
That was a very hot topic in our inquiry. We asked for employees to waive non-disclosure agreements, not because we wanted to know about individual names, but because we wanted those people to be able to talk to us about their general experience, and because it's really important to understand what the system, how the system works. And it was really educational for me to see the complete resistance to that from the majority of employers. There were about 35 large employers who said, we will let people talk to you. But I don't think the ones who didn't want to were very supportive of the inquiry. But our recommendation ultimately on non-disclosure agreements, because some people said you should ban them altogether, was that there is a role for them. Many people do want to get closure. They do want for it to not be spoken about, victims included. So our conclusion and our recommendation was there should be guidance on how they work. I'm not supportive of blanket non-disclosure agreements. So there is a clause, and I was a lawyer who drafted it. Corporates just put it in there. You'll never say anything ever about this ever again, including to, your future husband or whatever it might be. What I heard was it can be really harmful for people to be unable to speak about something that stays with them for the rest of their life. It also, as Kim has said, by complete confidentiality, organisations weren't learning, staff weren't getting lessons. So even if you de-identified it, you wouldn't, they weren't taking lessons from that. And the other thing that was really clear is non-disclosure agreements did give impunity and in fact recycle repeat perpetrators around systems, because you settle here, you move there, you settle there, you move here. So those three things were really damaging. But there were some good corporates who spoke to me about doing a non-disclosure clause that actually allowed all those things, so that we will share, for the broader purposes. And so the guidance, we're hoping to contribute to that to be developed.
Okay, we're getting a number of questions, and to anyone who would like to ask a question of the panel, please just drop a question into the chat at the bottom of your screen. We're getting a lot of questions about media in particular, and Jacqueline, I just want to bring this back to you. Columnist Jenna Price, who's written very strongly in this area, said at one stage that Australia is one of the hardest places in the world to prosecute stories such as this. Do you think that Australia's defamation laws need to be as tough as they are? That's a bit of a Dorothy Dixer, but I'd like to hear your thoughts about that.
No, I mean, it won't surprise you to know that I would say all journalists think that the defamation laws in this country are way too hard and, massively sort of throw the balance in favour of plaintiffs and basically, tend to protect the reputations of rich people and do very little else. They are very onerous to comply with as a journalist, and given we've had some large defamation damages payouts, notably Jeffrey Rush, in the last year, they've had a very, very chilling effect on the kind of reporting, the Me Too style reporting. We would like to see them changed. I know that media organisations, including my own, have been lobbying to have them changed, and I think the Council of Attorney Generals has just said that they're going to move on that. So they're going to introduce a public interest, or they want to introduce a public interest defence, which we don't have at the moment. It's not clear to me. The other lawyers might know, but it's not clear to me how that would interact with the truth defence. But any sort of progress or any reform in that area is welcome to journalists.
Indeed. Jacqueline, I also want to ask you about, you mentioned the Rush case, and without talking about the details, it is a reminder too, and a few people have mentioned this among our participants, there have been some women who have been pushed forward in cases around sexual harassment and their work that have actually not wanted to go public, but the circumstances have pushed them forward. Mm-hmm. Can you speak to the media's role when that happens?
Yeah, I mean, it's a very delicate thing, I think, and we've seen some really terrible cases of it that have obviously been very, very distressing to the women involved. And you've got to wonder, particularly, I guess, in the Geoffrey Rush, Erin Jane Norval case, you know, I mean, there were no good outcomes for anyone out of that, really. And certainly it was clearly a very distressing process for Erin Jane Norval to be hauled into that. And she was, you know, we knew from the beginning, or the journalists knew from the beginning, that she didn't want to be named, and not that the Daily Telegraph didn't name her, I should add, but she didn't want she didn't want the report to go anywhere. She spoke about it in confidence with someone at the STC, and then, you know, the rest is history. Mm. But I would also say, as a journalist, you wouldn't ever want to put down a blanket rule that the victim or the complainant of a crime or an incident like this would that you would never write about it without their consent. Because if you think about it, as a journalist, if you are going to always seek the consent of people that you're writing about, even when they've been victims or alleged victims of something, then half the stories in the newspaper wouldn't be there. So I think there's a way to do it. We had, you know, with the Dyson Hayden stuff, the incident that happened at Oxford University, which sort of cut short or meant that his tenure there wasn't renewed, and he left under a bit of a cloud. We knew, I knew who the complainant was. I knew a fair bit about her. I knew that she didn't want to come forward, and that she certainly didn't want to be named. I was never going to name her without her consent, but we just completely didn't put in any identifying characteristics at all. So, and we didn't write a lot of the information that we have, we didn't write. So, but we were still able to report it. And I think we struck a pretty good balance in that case.
Yeah, and look, I think you did too. I thought that was incredibly sensitively handled. But as you know, there are many more journalists working out there than you and your colleague Kate, and it hasn't always been the way that media has treated the women in these cases as well as they should, which actually raises another issue, and this has come up. We've got a couple of men online, and it does raise the issue around the male defendant in some of these cases. But also, I want to bring this back to Kate, because this is a really tricky one. We know that the majority of those who do make complaints, although it's only 1 in 5, but those who do make complaints about sexual harassment in the workplace are women. But of course, there are some men. But nevertheless, the issue is usually a woman complaining about the actions of a male. And until those actions or allegations are proven correct, there is a huge cloud over that male. What is your thinking around the protection of men in these sort of circumstances?
One of the things I found through the inquiry, my view is sexual harassment is something that should absolutely be an issue that men are really engaged in. They so in the 5-year numbers, 26% of men have been sexually harassed. 4 out of 5 harassers are men. Men are more likely to be harassed by other men, as are women. And they're the bystanders, they're the colleagues, they're the managers, they're the CEOs, frankly. So when I did the inquiry, women are highly engaged and actually quite sophisticated in their understanding about these issues. But one of my hopes is that this moment creates a bit of a turn where men are more engaged. So you're talking about men accused, but actually even so I actually organised some specific male only, obviously I was there, but otherwise all men, focus groups to just start having those conversations. And I never thought I would end this, but I did come to a point where I'm not a men are from Mars, women are from Venus, but on this topic, it is like worlds apart, you know, that women have, in terms of the behaviour and the nuance, have as a broad generalisation, quite a strong sense of the difference between a friendly hug and a creepy hug. And, you know, that's really oversimplifying it. But a lot of men were confused about what is in, what is out, what to do. If I see something, how should I respond? If I'm a leader, what should I do? How should I respond? And then if I'm accused, there is a bit of a formula that Jacqueline sort of talked about. So the response is deny, you know, say I'm going to sue you for defamation, you know, kind of there is a bit of a formula. The reality is sexual harassment covers a huge spectrum of conduct. And at the moment, our processes really only kick in if it's sort of at the sort of almost sexual assault or lose your job end. And yet the highest number of incidents are about everyday comments and jokes and things like that. So I absolutely stand by, if you're investigating, there should be a fair process, there should be justice. But what I heard was lots of women said, I'd love to be able to just say, could you not say that again, without it becoming some major thing. So I think culturally we're a bit all over the place on being able to just, you know, considerately speak to each other and kind of raise the tone and improve the respectful cultures in our workplace.
This conversation, and I mean this national conversation around sexual harassment, and certainly with the Dyson Hayden case and your report, has created nevertheless some real difficulties, I think, in workplaces about what's okay and what's not okay. I used to have a habit, for example, and I'm outing myself here, of pinching the bottom of our chief of staff, who was a fellow. I just did. I thought it was funny. I probably would get in trouble for doing that. I'm going back a couple of years ago. And I don't think he minded. In fact, I'm sure he didn't. Well, maybe he did mind. I don't know. But I mean, is that something that I would now get in trouble for? And some of these questions coming through from participants are actually asking these sorts of things about where do you draw the line? How do we know? And is that going to be clarified with reform?
So what we heard is when I spoke, particularly young people, their education is really poor, but they're often, I spoke to a group of 22-year-olds, and by that time they'd been in the workforce for 7 years, all casual, all cafe, you know, they'd been at uni. Their experience of sexual harassment was just shocking. Like one of the blokes said, not only did I not know this is unlawful, I got told as a bartender I should flirt more. I wasn't, you know, it's confusing our messages. I think we're in a moment where we just are starting to, as a community-wide, educate better on what respectful behaviour is. And I think all of the messages, so Our Watch's work and the media reporting that's more sophisticated and workplace conversations, is sort of improving our education on that. Because I think you said one of the things that I would like us to be able to get to is to say, this might have happened in the past, I might have participated in it, but I realise now that maybe I missed the mark. But there is a lot of guilt, particularly for men, about, you know, we can't talk about this because my affair or my, you know, something I've done will come up, and there's a lot of fear. And you use the word get into trouble. Like there's a lot of about this that is sort of feels like it's embarrassing and shameful. And so I think because there's a community-wide conversation, I feel like we're inching up, and all we're really talking about is cultures of respect, not perfection. That you will, you know, at some time that chief of staff will say, I'd rather you didn't do that. Or you'll think, he might be fine, but actually everyone else will be thinking that, you know, I shouldn't be doing it. So it sounds like you wouldn't do it now, I hope. And okay, we won't cover that now. We'll go offline.
Right. Yeah, look, I raise it because I just think, I know these sorts of conversations do go on about, you know, what is okay and what's not. Look, we're getting a lot of wonderful questions, and I'm going to try and get through them, many of them, in the next 10 minutes. Please, you know, feel free, those of you who are watching, listening, to send in your message. Jacqueline, back to media again. And Sarah's asked a really important question too. We were talking about, of course, the non-disclosure agreements, and she has raised the issue of the public interest defence in defamation legislation. Would that make it easier to publish these sort of stories without women's consent, coming back to our earlier discussion about women who don't really want to come forward and in fact try to avoid the media spotlight?
Yes, I think it probably would. I hadn't thought about it from the point of view of complainants or victims, but I don't know as well if they'd be so much in the purview of defamation law, because I don't know if a court would rule that it's defamatory to be named as the victim of this kind of behaviour. So I don't know how it would interact with victims. I think it would help a lot in reporting on power abuses, which is, you know, the Me Too movement at its best has been that.
Okay, thank you. Kim, in general, and this comes back to workplace culture and the prevalence of women in leadership. One of our participants has pointed out that that a large Australian organisation has recently appointed a new CEO who has a history of sexual harassment that has been documented. And yet that same organisation has impeccable gender equality strategies and policies in place. Now, here we go again with, you know, what you say on paper and what you actually do are two different things. And then the participant has asked the question, can public condemnation and I guess shaming really is that the only thing that's going to bring about understanding of big corporations that they can no longer make these sorts of appointments?
I don't think it's the only way of dealing with it, but it certainly is another expression of public power over those corporations if they are responsible to and are needing public support for their own activities. Then if there is a clear condemnation, then that must go into their decision-making process. But I wouldn't mind bringing it back to sort of even more fundamental cultural sort of frames of thinking about the workplace and us as human beings in the workplace. And that actually links into the work that we're doing at the 50/50 Foundation in thinking about, if you really want 50/50 in the public sphere, you need to address the private sphere. What is going on in the home and what are the power relationships and just norms that are created in the home that then play out in the public sphere, so that in essence, we need there to be 50/50 in the private sphere. And what I mean by that is unpacking the unpaid work at home, the responsibility over care in the home. And I think it was really interesting that Josh Bornstein, one of the lawyers in the Hayden case, and again, without going into the specifics, but his op-ed last week in The Age was actually saying we need to be mandating and to be encouraging parental leave. He was reflecting on his own time out with his own kids and what impact that has on men, the positive outcomes of men staying at home with their kids, flowing on to the way they are as human beings beyond the home. And I think that this is really something, you know, it's obviously a huge issue in terms of gender norms and gender equality in society. But I do think it links back to the way men behave in the public sphere, and that if they are more relational, have more a sense of responsibility and care to both their, to all their children, and have a sense of what vulnerability is as a child and one's responsibility over those who are vulnerable, playing out in a real day-to-day sense, as opposed to at the end of the day coming home and being involved in the peripheries of home life. I think that that also is profound in influencing the cultural norms and expectations, not only on terms of sexual harassment, obviously, but in terms of a commitment to equality in the workplace. And I think we need a lot of work in that area.
I think that's beautifully put, Kim, and a really, really important point. And it also, it raises the issue too. We've all seen over the last week AOC in the United States with that wonderful speech she gave on the floor of Congress and pointing out that the very man who had been, the congressman who had been so despicable to her, tried to claim that he wouldn't be offensive to women because he was a father, he was a husband, etc., when in fact, as she said, that doesn't excuse anything, and it actually doesn't mean a great deal in that kind of sense. So, as you point out, the issue of men becoming more relational and having a greater connection to families is such a fundamental thing.
And I just finish off, sorry, Virginia, the other point that I just wanted to add there is, as you well know, but perhaps not many of the viewers know, that you were the former director of the 50/50 Foundation, and now we have a co-directorship. Me and Trish Bergen are co-directors. And I think the other aspect that I would say is about unpacking our notion of leadership, and that leadership and power is not necessarily a singular notion. And again, being more relational about the way in which we exercise power and we exercise leadership. And part of our co-directorship of the 50/50 Foundation is also wanting to raise and discussion about more shared leadership, differentiated leadership, diversity in leadership, and that all of these things then do have the capacity to influence culture in a much more fundamental way.
Indeed. Kate, on the issue of men in leadership, it was quite surprising after Jacqueline's piece came out to hear or to see other senior men in the legal industry writing about how they were very aware of this culture of sexual harassment, and had been, in fact, one of the quotes was, "It had been swirling around me for 30 years. And he had seen, this was the Silk saying this, he had seen women's careers broken and women leave the industry. What is it about men just not speaking up when they know what is going on, and they also know how damaging it is?
Look, through the inquiry, what we know is from our latest survey, that whilst people who report have stayed at around that 17%, there is an increased number of people that we call bystanders. And I think that's some about the education. People now see sexual harassment. Some of it might be more, but others is people are now a bit more sensitized. When you hear something or see something, you think, actually, that's probably not, we're reading the newspapers, we're learning. But what we found in the last survey was that actually the number of bystanders that acted had dropped. So I think on the last survey in 2012, it was about 1 in 2 bystanders do something. They might talk to the person, they might take some action, speak up at the time. But in our latest survey, only 1/3 of people acted. And so as we went around, and I think it's so helpful, those men speaking and on social media. But what I heard was that not just women, but also men bystanders felt that their careers were also at risk. It is not, so if you're talking about the people in power, that they're also viewed. And I had some actual examples, and they're only individuals, so we didn't write them as a major evidence base, but some male men in senior roles who had stood up and who had been knocked down for that, and who hadn't got the next contract. And so I think the victimization of bystanders is alive and well as well, and that includes for men. But I do think there's power in numbers, and men are starting to realize that they're not taking. So I also heard men kind of felt like it wasn't their role to speak up on this, but we're really encouraging them. And I think that some of them are really saying, okay, I'm going to get a bit more courage, and I'm going to start speaking about this, because it's actually a lot worse than I had realized. So I think them speaking is really important, but I also think men pay the price, particularly if they're not the most senior men. It's counter the culture of what they should be doing as masculine men as well.
Which again raises the importance of us having these sorts of conversations among our male partners as well, and not just among ourselves. We're going to have to finish up in a moment, but I am getting a lot of wonderful questions. So thank you to everyone who's writing in. We can't get through them all, I'm sorry. But Jacqueline, also back to you with media questions. once your story came out, I'll just have to paraphrase this, but once your story came out, have you sensed that more willing, now that the High Court story has broken, that more women are going to be more willing to contact media and discuss these stories or share these stories?
Yeah, I do. I think that's the beauty of having such a high profile person being brought to account for these allegations. That and we saw it, I think, in the recent case with AMP Capital. Once that story was broken by, it was Michael Rodden at the Financial Review, there was a huge uproar within that organisation. And I think, I mean, you know, maybe Kate could shed light on this, but I think 5 or 10 years ago, there wouldn't have, you know, women within the organisation probably wouldn't have felt so emboldened to voice their, you know, very sturdy complaints over this guy who had been, you know, the subject of a sexual harassment complaint, but still promoted to the top job nonetheless. And yeah, I think that the more women see that the culture's changing a little bit, that people are being held to account for it, and that other women are speaking up, the more emboldened they'll feel. And that means hopefully that it'll happen less.
Mm. That has been an extraordinary story. And just Kate, on that, do you agree with that in fact we wouldn't have had a revelation like that 10 years ago, even 5 years ago?
Yes, I do think we're at a tipping point, and of course I'm going to be optimistic about that, but I do think it's because there's so many things happening all at the one time. So yes, I do think it's shifted towards the other way, and corporates in particular now are more concerned about dealing with it than hiding it. And I think that's a really positive step towards change.
And on that optimistic note, we will wind it up, but we also need to ensure too that we don't become complacent. We don't feel that there's been an outing of discussion, and that's great, and then stop the momentum moving forward for improvement. I have also just received a message from one of our participants just noting that there has been an excellent ILO report released just a couple of days ago, also on sexual harassment in the workplace, for those who'd like to take a broader look at it. And I would also like to extend to anyone listening who has been moved or upset by this discussion. We well understand that and do urge you to use the 1800 RESPECT number, which is available 24/7 counselling, and also Lifeline. Please do continue to send us your messages into Broad Agenda or via our Broad Agenda Facebook site. I want to thank, before I thank our panellists, Julie Hare, who's our Broad Agenda editor and the producer of the Broad Agenda Public Talk series, and Dr. Pia Rowe, our academic editor, and Kate Burney, who is our Associate Director at the 50/50 by 2030 Foundation. And of course, thank you to all of you who have joined us. But a big thanks for engaging in this discussion to our panellists. I know everyone is busy and tired of Zoom get-togethers, but I think this has been really, really worthwhile, and hopefully we will have sparked further conversation in workplaces about this important issue. So to Kate Jenkins and Jacqueline Maley and Professor Kim Rubenstein, thank you very, very much for your time. It's greatly appreciated, and thanks to all of you who have joined us online. Sorry I didn't get through all of the questions, but hopefully we will on Facebook. Thank you and goodbye.
Thanks, Virginia.
Thank you. Thanks, Virginia.